Hi, my name is David Holt, and this is the screencast for week 2 of copyright, dealing with infringement, remedies, renewal, and restoration. We're going to start with a discussion about duration of copyright, renewal, and restoration. Duration of copyright depends on a few factors. They include when and if it was published, if it was properly renewed, if it contained proper notice, and where published, as items that are published outside of the United States may have a different duration period than those that are published within. If you go to the Copyright Office's website, there's actually a flyer on copyright duration, but I'd like to point out this website from Cornell that deals with copyright term and the public domain in the United States, and you can see a broad overview as to the duration of various types of published and unpublished works. And notice our big dates here are, of course, 1977 and 78, when the 1978 Copyright Act took effect, and 1909, which was the predecessor to that act. Copyrights can be renewed. Prior to 1992, copyright owners were required to renew during the 20th year of their copyright term to be eligible for the renewal term. That process ended in 92. Now renewal is automatic, but you still need to look at whether an author properly renewed during their 28th year for items that were published before the 78 Act. Copyright restoration pertains mostly to works that were published outside of the United States and that would not have met the formalities requirement had they been published within the United States. Because of treaty obligations the United States has entered, those materials that were published outside of the United States and did not meet the formalities requirements and were previously in the public domain may have their copyright restored. Okay, rights and limitations. Title 17 of the U.S. Code, Section 106, lists the rights that are conferred to copyright holders. They include the right to reproduce, prepare derivative works, distribute copies, perform and display publicly, and perform publicly by means of digital audio transmission. Let's take a look at the Copyright Code in Westlaw. And you can do this a few different ways. You can just simply enter in U.S. Code here in the main search field, and then scroll down to United States Code Annotated. And again, it's going to be Title 17 for copyright. And you'll see here in Chapter 1, which covers subject matter and the scope of copyright. It deals with copyright and restored works, the subject matter of copyright. And we have our fair use, limitations on exclusive rights. The exclusive rights that I just mentioned are listed here in Section 106. We do, as you may have noticed from the code section here, we have limitations on those exclusive rights, and they include fair use, reproduction by libraries, ephemeral recordings, secondary transmissions by cable. If we go into the section on fair use, which is 17-107, there's a four-part test that courts generally adhere to when analyzing whether use is within fair use. And that includes the purpose and character of the use and whether that use is commercial or for nonprofit educational purposes, the nature of the copyrighted work, the amount of the work that's being copied, and the effect on the potential market. In terms of infringement, liability, and remedies, that is listed in Chapter 17 of the U.S. Code. For copyright, we have actual damages that are available for plaintiffs, meaning that they can acquire the defendant's profits, and there's also injunctive relief available, so impounding and destruction of infringing articles. Also, cost of suits and attorney fees may be a possible remedy, and statutory damages are also available. Statutory damages can be pretty significant for copyright infringement, as you'll notice in the subsequent assignments for this course. Okay, for the coming week, you should have already completed the copyright application assignment, which is due on the 14th, in addition to Prince's Vault, the discussion assignment. And then the 21st, the two assignments that are due for week 3 include Who Owns Klingon and the copyright infringement assignment. I want to go over a little bit about the patent law exercise that we have coming up for week 4. The patent law exercise is based on an actual case that was filed with the Northern District of California 3 years ago. The goal for this assignment is to look at the model documents that will typically be used in a patent infringement proceeding. For one, I want you to be able to look up federal court filings on either Pacer or Bloomberg, and then to find model documents that would be used for that particular case. You may need to refer back to the screencast on practice materials, as that will go over the form books that are available, model interrogatories, model agreements, other practice materials that are going to be used for that assignment. Let's spend a second going over how to locate dockets here on Bloomberg. If you click on Litigation and Dockets and then Search Dockets, you can select the courts to search within here in this field. If you're searching by docket number, however, you can just simply enter in the docket number. And so let's go back to our assignment for patent infringement. And this is the docket number. We're going to copy and paste that. And sometimes you'll see that there'll be more than one case that is associated with a docket number, and that's because I'm searching within all the federal courts. Had I specified the Northern District of California, I would have only gotten that one result. So let's look at the party names here. It's Linux versus Hewlett-Packard. And here it is at the bottom of the list, of course. Let me point out a few things here. Again, the docket number, the 2-digit code here stands for 2013, the year that the case was filed. CV stands for civil. The 159 is the numerical sequence in which this case was filed for that year. And CW are the initials for the trial court judge that this was assigned to. You'll see the cause of action here for this case is patent infringement. The number that precedes patent infringement here refers to Title 35 of the U.S. Code, Section 271, which if we go to Westlaw here, 35 U.S.C. 271, we'll see that that deals with infringement of a patent. Scroll down here, and I want you to look at the complaint that was filed, and to do that you can click on the view link here in the docket. What Bloomberg is doing here is pulling that document from Pacer, which is the electronic filing system for the federal courts. And then you can click on Part 1, which is the complaint itself. Now in the assignment, I ask you to state the statutory cause of action and to find secondary materials that give you guidance as to how, as to what those elements are in that cause of action. And for some reason, we're having a delay here. Let's try this again. There we go. And so you'll see the nature of the action, statutory cause of action is 35271. The patents that are potentially infringed are listed here. I should point out that you can easily search for patents now using Google, but also the USPTO website. So if we opened up a new tab here and entered in the US patent number, the first result is going to be the patent search engine from Google. And it's going to give us lots of information as to who is the original filer, the publication type, when it was issued, the images that were included in the patent filing, and what's being claimed. If we click on the external link to the USPTO here, it's also going to give us the classification schema that was used by the USPTO to classify and organize this patent filing. Okay, if you have any questions about this week, please feel free to reach out to me via email. I am still at dholt@scu.edu. If you have any other questions, not only about this week, but about any of the preceding or upcoming weeks, please don't hesitate to ask for help.